Welcome to part one of Essential Supreme Court Cases. Okay, the first case we're going to go over is one called Marbury versus Madison. To me, this is the most important Supreme Court decision ever cast by the court because they created something called judicial review. And you'll understand what that means when we're finished with this. Okay, so here are the facts of the case. So in 1800, there was an election between Adams and Jefferson won. It's the first time that in American history that we went from one party to another. We went from the Federalists to the Democratic Republican Party. And as you know, the justices in the federal judicial branch are appointed for life. So what the Federalists decided to do at the end of right before Jefferson was supposed to take office was they created a new Judiciary Act and packed the federal courts with people that they could appoint for life. So they created a whole bunch of new judgeships. And they were, of course, Adams was going to appoint Federalists, and these Federalists would serve in these positions for life. Because Jefferson was a Democratic Republican, they lost control of the Federalists, that is, lost control of the presidency, and they were about to lose control. A new Congress was coming in, and they were going to lose control of the House and the Senate. So what Adams did was appointed these lifetime appointments to Federalists. Now, these were literally midnight appointments. They were running out of time. At that time, at midnight in March, I think it was March 4th, we've changed the inauguration date, but that's when the new president starts his new term. So they actually literally were like at 11:55 p.m. The Secretary of State was in charge of putting the paperwork together. Secretary of State at the time was John Marshall. And he was getting the paperwork together, and he had to get Adams to sign it before midnight. One of these folks was William Marbury. And what happened was they literally ran out of time. And by the time the new administration came in, the new Secretary of State was James Madison. So Marbury's paperwork hadn't been finished, and it was sitting on Madison's desk, and it was his and I think about 24 other judges. So Madison brought it to the new president, Jefferson, and said, "Hey, look what I found on my desk. I found all this paperwork that hadn't been finished. It needs to be signed by the president. Do you want to sign these?" And they took a look at it and said, "No way. Let's appoint new judges. Let's appoint to these the judges whose paperwork wasn't finished. Let's make them Democratic Republican appointments." Well, one of those, of course, was William Marbury, and he sued Madison, and because of a flaw in the law, the way the law was written, the Supreme Court actually had original jurisdiction in this case. So the original jurisdiction means that's where the trial was held. So actually, the trial was held in the United States Supreme Court. That's a rarity. That really doesn't happen too often. Okay, so what he was looking for was Marbury was looking for a writ of mandamus, which is a writ of mandamus is a directive by a judge to a federal government official to perform the duties of their office. So he was looking for a writ from the court to give to Madison, the Secretary of State under Jefferson, the order to give Marbury to finish the paperwork, basically, so Marbury can have his position. Okay? Now, by the time this case came to the Supreme Court in 1803, this was 3 years later, the original Secretary of State, ironically, John Marshall, he was Adams' Secretary of State, he ran out of time. He found himself in 1803 as the Chief Justice of the United States Supreme Court at that time. So he could actually help rule this opinion. And now he could do, if he made Madison do the writ of mandamus, then he obviously would get his job, and Marbury would get his job, and all the other Democratic Republicans would get their job. The other Federalist judges would get their job, and that would help his party, John Marshall's party, stay in control of the the judicial branch, but he decided Madison won this case because Marshall, as Supreme Court judge, got all the judges to go along with him. They said the 1789 Judiciary Act, which created the system that gave or created Marbury's position, was unconstitutional. It changed the wording of the Constitution, and a law, you should know this, a law of Congress is not allowed to change the wording of the Constitution. So this law, the Judiciary Act of 1789, further defined when a case could go to the Supreme Court under original jurisdiction. Only the Constitution is allowed to do that. If you want to change the Constitution, you know this, you have to add an amendment to the Constitution. So, John Marshall, the Chief Justice, wrote the opinion, said this act 1789 Judiciary Act was unconstitutional. Therefore, William Marbury is not entitled to his position. Okay? Now, this was important because this is the first time that the Supreme Court overturned an act of Congress. That's called judicial review. That's the Supreme Court's ability to declare a law or an act or an action by a federal government official, including the president, unconstitutional if it violates the Constitution, which they said that 1789 Judiciary Act did. So that was the first time, and the first time that they said a act of Congress was unconstitutional. This is important because this elevates the prestige of the not just the Supreme Court, but the entire federal judicial branch, because it made them a co-equal branch of government with the legislative and the executive, because they could review the actions of both branches and determine if they're correct under the Constitution. All right, now let's move to a couple of federalism cases. Okay, the first one is McCulloch versus Maryland. Remember, federalism, by the way, let's backtrack a second. Federalism is the relationship between the state, federal, and local governments. And the way our system is set up, there are specific things that the federal government can do. One is print money, declare war, determine who can come into the country via immigration and so on. And there's things that states and local governments can do. States can issue licenses. Local governments take care of the roads. So those they all have their separate powers. Some powers they do share, like taxation. So there are some shared powers. But the way federalism is supposed to work is if one government has that power, the other government, another government, cannot take over that power. So if there's something like, the states issue your driver's licenses, the federal government isn't allowed to take that power away from the states unless there's an amendment added to the Constitution. So, under the Constitution, the Second Bank of the United States was created. Okay, the Bank of the United States was the bank. It's no longer in existence. It was unchartered, or actually its charter ran out. It had a time limit on it and it ran out. But it was actually a bank where the federal government when they collect taxes and levies and so forth, it's where the tax collectors brought the money. So there was, they would deposit it in the Bank of the United States, and that was the bank that the federal government used for its finances. But you could also go into these banks and set up your own accounts. So they were a commercial bank as well, not just the government bank. Well, Maryland didn't like this because Maryland didn't want any big, giant national bank coming in and killing the rest of their the banking business in Maryland, all the other banks, because as you probably understand, a big corporation like the Bank of the United States, it's hard for the little businesses to compete with that. So they were worried about that. So Maryland passed a law saying that a tax on any notes of banks not chartered in Maryland they weren't illegal, but they had to pay a tax to the state of Maryland. So basically, these would be fees today. A lot of banks use fees. If you use an ATM machine, they charge you $3 or $3.50. That fee added on top of that. That's what this would do. So this fee would then would go to the to the government of Maryland. What Maryland was trying to do was trying to make its citizens realize, hey, I can use a Maryland bank, not pay any fees. If I go to the Bank of the United States to do my banking, I got to pay all these extra fees. I'm not going to go there to do my banking. So what I'm going to do is I'm going to use the Maryland bank. So basically Maryland put this in existence to kind of make the Bank of the United States leave Maryland. Okay, because even though they said that the tax was on all banks not chartered in Maryland, the Bank of the United States was the only out-of-state bank that was operating in Maryland. So even though it was kind of generic on who, when they passed the law, it was specifically aimed at the Bank of the United States. Now, I don't know if you remember this from the very, very beginning of the year, but one of the powers of government we talked about that you learned about was delegated powers and implied powers. And there's reserved powers. Delegated powers are the ones specifically given to the United States federal government in the Constitution. So the power to coin money, the power to collect taxes, that's all in the federal Constitution. Okay. Implied powers are used to carry out, are new powers that are created to carry out the stated powers in the Constitution. So it says the federal government can levy and collect taxes. It uses the Internal Revenue Service to do that. You won't find the words Internal Revenue Service in the Constitution, but Congress was allowed to create the Internal Revenue Service because of an implied power. Well, if you have the power to tax, well, how are you going to collect it? It's implied that you can create an institution to collect the taxes. Okay? Now, that's one question. Does the Constitution grant Congress the power, the implied power, to create a Bank of the United States? The second question is, can an action by a state interfere with a valid constitutional exercise of power by the federal government? So they first had to decide, is this bank legal under the Constitution? And then second, if it's legal, is Maryland trying to interfere with it, with the operation of the bank? Okay, and now, so once again, John Marshall, he is still the Chief Justice of the United States. He gets a majority of judges to go along with him, and they state in their opinion, their majority opinion, that the necessary and proper clause, the implied power clause of the Constitution, allowed Congress to collect taxes and to charter a national bank to do that. Okay, it was exercising its power to regulate interstate commerce and coin and regulate money. And those are things that are specifically mentioned in the Constitution. Okay. The second question, which is can a state interfere with a valid exercise of a federal power? Since the bank is valid under the majority opinion, then a state can't do that. They're actually violating federalism. So Marshall wrote that, this is the most famous quote in this opinion, is the power to tax is the power to destroy. In other words, why is Maryland taxing the Bank of the United States? Because it wanted to destroy the Bank of the United States, and it's not allowed to do that. Okay? It violated the Supremacy Clause, which is Article 6 of the Constitution. The Supremacy Clause said, whenever there's a valid exercise of federal power under the Constitution, a state and local government is not allowed to interfere with that. If ever there's a conflict between a state and a federal law, the federal law is going to win as long as that's a valid exercise of federal power, and which is what they decided, and the bank therefore is illegal. Now, what's important about this is the first time a state law was declared unconstitutional by the United States Supreme Court, and it really defined what federalism is. Okay, now, a more recent federalism case is one called United States versus Lopez. This was decided by the court in 1995. Okay, it's centered on the Gun-Free School Zone Act, which in theory is a good idea. Okay, it banned handguns in or near schools, 1,000 feet. So picture, Northwest High School, 1,000-foot radius around the school. All guns are banned to keep students and staff safe. It seems like a good idea. Congress enacted this, made these gun-free zones around every school in the United States. Now, you may be asking yourself, what power does Congress have to ban guns? What power does the federal government have to ban guns? It used what's called the Interstate Commerce power. The Interstate Commerce power, as it has been defined over the years, is one of the most powerful powers that the federal government has. Any business transaction that crosses state lines, whether it's actually on a physical, like a truck, and it's being, transported from Ohio to Kentucky, that's interstate commerce. Or if one business in Ohio is doing business with another company or customers in Kentucky, that's interstate commerce. The federal government can regulate that. Now, the big question was, is this a valid use, this Gun-Free Zone Act, is this a valid use of interstate commerce power? Up until this time, 1995 was this case, when this case was decided. Up until this time, the federal government used the interstate commerce power, and the Supreme Court generally went along with it. They gave deference to Congress and the president to say, yeah, because, think about it. Guns aren't manufactured in one state. Usually parts come from all over the states, and they're assembled in one state and sold in another state. So they said that's interstate commerce. Well, here's what happened specifically in this case. This is the Lopez in United States versus Lopez. This guy, Alfonzo Lopez Jr., he was a 12th grader at Edison High School in San Antonio, Texas. He carried a concealed .38 caliber revolver along with 5 cartridges into the school, which sounds like a stupid thing to do, and it was a stupid thing to do. Okay, the gun was not loaded. He brought it to school. You might laugh at this or think, what an idiot. He brought it to school because he sold it to another student for $44. Okay, now, every year I go over this, I say the stupid thing was he brought a gun to school that, he had sold. It wasn't loaded. Students say, oh my God, I can't believe he sold the gun for $44. He could have got a lot more money for that gun. So I don't know what went on there, but he was arrested for violating the law, the Gun-Free School Zone Act. He was fined and convicted. He was 18, so they sent him to big boy justice. They sent him to a big boy judge. He didn't go to juvenile court. So he went to adult court, and he claimed that this law was a violation of his rights, and it was, the law itself was unconstitutional. Well, let's look at the two sides. Okay, the federal government said possession of a firearm. Actually, let's go to Lopez first. This is easier to understand. He said, his lawyer claimed, it's beyond the power of Congress to regulate control over public schools. Okay, that's a state function. That was rejected by the court. The court accepted this argument. The law exceeds Congress's power to legislate under the Commerce Clause. He wasn't involved in interstate commerce. He had this gun and he was selling it to somebody in a school. As stupid as that sounds, that was, he said that goes beyond, Congress can't regulate that. They can't make that illegal because it has nothing to do with the Commerce Clause. Here's the arguments that the federal government used. Okay? They didn't do a very good job here. And I'm kind of foreshadowing this, that Lopez wins. The federal government says violent crime causes harm and creates expense. It raises insurance costs, which are spread throughout the economy. So that's how insurance works. You share the burden of an accident, like your car insurance. And if a lot of people have accidents, then everybody's car insurance goes up. In this case, this is going to cause crime. It's going to cause harm, and it's going to raise insurance, health insurance costs, and so forth. And everybody's going to pay. The court rejected that. Second, by limiting the willingness to travel in an area perceived to be unsafe. So that's why they created these zones around these schools, so people would feel safe around schools. You take that zone away, and people are going to say, well, I'm not going to go by that school. I could get shot because there's guns all over the place, within 1,000 feet around that school. The court rejected that argument as well. The next one, the presence of firearms within a school. This is the one that students always say, okay, I kind of see the first one and the second one, but you lost me on this one. Presence of firearms within a school is seen as dangerous, resulting in students being scared and disturbed. Then, because they're scared and disturbed, that would inhibit their learning, and they might not even go to school. They might be afraid to go to school. That would lead to people not getting educated. That leads them to be undereducated. That would lead to a weaker national economy, since education is critical to earning a good living. The court rejected that one as well. And they declared, the Supreme Court declared a 5-4 decision, even though this law is a good idea, it still has to follow the Constitution. They said the act is unconstitutional, and it's the first time since the 1930s, remember this was 1995, that the court limited the commerce power of the states. I'm sorry, the Commerce Clause power of the federal government. It said, nope, you went beyond that, therefore that law is unconstitutional.